well. So Norman has given you cases that illustrate the very strong speech protective nature of modern Supreme Court First Amendment free speech law. And I emphasize modern because for most of our history, the First Amendment with its free speech guarantee was a dead letter, you know, along with the Equal Protection Clause and other wonderful language in our Constitution. It is not self-enforcing. It is not self-executing. And it is not until people have an understanding of what their rights are, so they know when those rights are violated and can go to organizations such as the ACLU, the NAACP, many others, to stand up and advocate their rights, that those paper guarantees, as James Madison, the author, well, he used a different term back in the day in the 18th century, he called them parchment, mere parchment barriers between we the people, our freedom, and government abuse. So they were finally turned into a reality starting in the second half of the 20th century. No coincidence at the very same time that the Supreme Court was breathing life into the Equal Protection Clause in the cauldron of the civil rights movement. If you go back and you look at the great First Amendment cases, a huge percentage of them came out of the civil rights movement because government considered that expression to be incendiary and subversive and traitorous and dangerous and emotionally disturbing, all of the negative adjectives that we hear about controversial expression today. Norman